मैं माननीय मंत्री जी को बधाई देता हूँ। धन्यवाद।
श्री बी महताब जी।
Madam Chairperson, I stand here to participate on this bill. As has been stated, media is not only confined to periodicals today or printing materials as it was in last century or year before last, 18th century, 19th century and 20th century printed materials were treated as media. Subsequently, with the advent of electronic media, with the support of satellite, media has undergone tremendous change. What we are discussing today is relating to print media, printed periodicals as it is said. And there I would say it is uneven. When media has been categorized in 3 to 4 categories, print media is only one part, electronic or audiovisual media is another, social media is also another, which is also in 2 parts. And what provisions does the government is making to make those alternative media, if I can say so, electronic media or audiovisual media and social media to be under provisions of this type of act. There are 4 or 5 issues which is of concern here, which is being discussed here. One is replacing the PRB Act by PRP bill, as we can call it. And it empowers the Press Registrar General to a very great extent. It streamlines penal provisions. The new bill contemplates a maximum imprisonment of 6 months if a periodical is published without a registration certificate and the publisher continues printing despite receiving a direction from PRG for 6 months, Press Registrar General for 6 months. This step aims to balance regulation while providing some relief to publishers. And the 4th point is introducing appellate authority. And 5th is exclusion of books and digital intimation. And now the books fall under the domain of the Ministry of Education, whereas the printing material will be under the purview of Press Registration Register of Press Registration General. The Press and Registration of Books Act 1867 was enacted for regulation and printing presses and newspapers for preservation of copies of books and newspaper printed in India. But this reminds us of the history that when first there was a hanging of Nandalal in Calcutta, when it was printed by a Britisher, and he was prosecuted, and after that all these provisions came into being. The Act has been amended many times. Between 1870 and 1983, it remained peculiarly cumbersome and complex, making it extremely burdensome and time-consuming, especially for small and medium publishers in matters of verification of title and obtaining of certificate of registration for publishing a periodical. The need of the bill today is that we are in a free time, present age of free press, and there is a need to uphold media freedom. This pre-independence archaic law is not in sync with the current media landscape. Therefore, it is necessary that the proposed legislation is based on the spirit of upholding media freedom and ease of doing business by making the entire process of allotment of title and registration of periodical simple and simultaneous, as it has been said by the Minister while introducing this bill, through an online system without the requirement of any physical interface, which would be fast-tracked by the Press Registrar General thereby ensuring that publishers, especially small and medium publishers, face little difficulty. But what is the stand of the courts? The courts have generally adopted a narrow interpretation to the provisions of this Act. In other words, they have tried to preserve the fundamental rights of the publishers whenever the Act has been invoked. For instance, in Gopal Das Sharma versus District Magistrate, the court emphasized on the fundamental rights of the publishers and held that the officials need to mandatorily adhere to the principles of natural justice while assessing applications and declarations under the Act. Similarly, in K.A. Muhammad versus Revenue Officer, the High Court held that the government officials cannot place additional conditions on the publisher for publishing newspapers over and above the ones in the Act. The court came down heavily on the officials for imposing the requirements of a police no objection certificate and looking into antecedents of the publishers before accepting his declaration. In fact, time and again, the courts have called for its repeal, given its unnecessary provisions that it impacts particularly on the freedom of speech, especially which was Institute of CA of India versus Union of India 2005. So the balance was needed to be brought in. The good aspect of the bill is, earlier the publisher submitted the application to the district magistrate, which was subsequently forwarded to the RNI, Registered Newspaper of India. After thorough deliberation, the RNI approved the title, but this procedure was deemed overly complicated and lengthy. The process for applying has now been streamlined. Secondly, the bill has also decriminalized earlier provisions of the Act. This will further the cause of freedom of press in the nation. But there are certain concerns, and lastly, I will give certain suggestions. The concerns here is, especially raised by Editors Guild of India, in Section 6B of the bill, authority is granted to press register, as well as any other designated authority to access the facilities of a periodical for the purpose of examining or duplicating pertinent records or documents or posing any necessary questions to obtain information required to be provided, unquote. The ability to enter a press organization granted by this provision is excessively invasive. When the government is saying, especially relating to income tax or even indirect tax, that we will not be invasive, through this provision in this bill, the officers or the persons who will be entrusted with this job will be invasive. It is disconcerting that despite the claim in the statement of objects and reasons that the intention is to streamline the process for press organization, such power are retained from the previous Act. Furthermore, under the new bill, the press register can authorize any person who is a gazetted officer of the central government, subordinate to her and authorized by her in writing to undertake any verification of circulation figure of a periodical. Since Press Register General can give the power to any central government gazetted officer to conduct his function with respect to verification of circulation, this would also mean that the central government officer could be allowed to enter the premises of the periodical's management building. I have certain suggestions. I think this needs to be looked into because there are a large number of officers and periodically they go to check the circulation figure of respective periodicals, and which they do it once in 2 years or once in 3 years to check that. And every time the newspaper organization also submit an annual report to the press register also, to the RNI also. I have certain suggestions here to make. Under Section 6A, the Press Register General has been given the power to obtain annual statements of a periodical. In order to facilitate the ease of doing business and to further the cause of Digital Bharat, it must be ensured that this is carried out digitally. In Chapter 6, the bill advocates for the establishment of an appellate board, a commendable measure that introduces an extra avenue for the aggrieved to present their case. Nevertheless, there is a need for further clarification concerning the composition of this appellate board, including details about its members and their qualifications. I firmly believe that regional representation should be incorporated into the composition of the appellate board for a more inclusive and equitable structure. The contemporary landscape, Madam, it is noteworthy that every registered newspaper and periodicals maintains a digital presence, disseminating articles through online platforms that may occasionally diverge from their traditional print counterparts. This evolution prompts critical inquiries into the regulatory mechanisms for such digital content. Questions arise about how these divergent forms of publication will be governed. Furthermore, the governance framework for online media platforms warrants careful consideration and articulation, given the distinct challenges and characteristics inherent in the virtual sphere. A helpful suggestion is for the central government to intervene and revitalize the industry by eliminating import duties on newsprint and introducing a scheme to encourage local production. The present minister at one point of time was also part of the finance ministry. Therefore, I take the advantage of suggesting this to him. Currently, India heavily depends on newsprint imports and is the largest global importer, with 45% sourced from Russia. The ongoing Russia-Ukraine crisis and associated sanctions have led to shipping containers delays, causing newsprint supply shortages. This, in turn, has resulted in higher import costs for domestic newspaper companies, with newsprint accounting for 45 to 50% of their total expenses. Consequently, prices have surged from $450 per ton to $950 per ton. This price escalation renders the newspaper business increasingly uneconomical, even leading to losses. Domestic manufacturers are adapting by converting their mills to produce packaging materials. As I had stated earlier, Madam, that media has undergone tremendous change. From 18th century, now we are in 21st century. And in 21st century, the print media is facing challenges from electronic media, especially the audiovisual media and also from social media. So media is now multiplying in different ways. Communication has multiplied in very many ways. In that respect, restricting or in a way putting conditions and in a way, I would say, to control the print media is not that good. It is necessary that equally certain measures also need to be taken to administer restrictions on social media, which has in the last bill on telecommunication we have gone through. And I believe the minister will look into the problems of print media of this country that country is facing today. Thank you, sir. Thank you.
बहुत अच्छा